There are 7 principles that you must know when it comes to processing data. My name is Liaw. I'm an employment lawyer and a principal at Liaw Chambers. As an employer or you're a HR manager, when you are dealing with employees' data, there are 7 principles that you must follow. The PDPA is not so much tell you exactly what you need to do, but it's telling you the 7 principles that you must know, that you must follow. As long as what you do can say that you have fulfilled these principles, then you are in compliance with the law. The 7 principles is the general principle, notice and choice principle, disclosure principle, security principle, retention principle, data integrity principle, and access principle. Is it an offense to contravene any of these 7 principles under Section 5 of the PDPA? It is a criminal offense if you breach any of these principles. Let's go to the first principle, general principle, which is that an employer is required to obtain the employee's consent before processing their data. Collecting, using, organizing, sharing is all processing. So as an employer, you must obtain the consent of the employee when you process this data. There is no need to obtain consent if it is necessary for the performance of a contract to which the data subject is a party, for taking steps at the request of the data subject with a view to entering into a contract, for compliance of any legal obligation to which the data controller is the subject other than an obligation imposed by a contract, in order to protect the vital interests of the data subject, for the administration of justice, or for the exercise of any functions conferred on any person by under any law. So in these scenarios, there is no need to obtain consent. But otherwise, you want to process, you want to use it, you should obtain consent. Now, consent can be obtained in different ways. It can be obtained by verbal, it can be obtained by conduct or performance, it can be obtained by silence, but when it comes to sensitive data, it must be obtained by explicit consent. For example, what is like by conduct? You can consent. If a candidate sends you their resume, they already know that by sending you their resume, they are giving you their data. And they know that by giving you this data, by conduct of them sending this resume, that you are going to process this data. You're going to save this data. You're going to save a copy in your system. You may want to share this data with management to see who is a suitable candidate. So by their own conduct of sharing this CV with you, they already by conduct consent to you to process this data. So even though you didn't explicitly ask them, can I process your data? Can I keep this information? Can I save this information? Can I transfer this information? By their conduct, they already give you that consent. That's why consent sometimes can be provided by conduct or by action. What do you mean by silence? Silence is when we say that, okay, give you a PDPA notice. By continue using our website, you agree that we can make use of this data. So if the person continues to use the website, continue going into your offices, even though they see the PDPA notice, they didn't say anything, then also by their silence can be deemed as they have consented to you using those data. But when it comes to sensitive personal data, like the medical information, biometric data, religious beliefs, political opinion, all these you will need explicit consent. You cannot use silence, you cannot use conduct. You must have an explicit consent. And the best way to do explicit consent is by giving them a form which they say, we will collect and we will process your sensitive personal data. Are you okay or not? And let them say, yes, I am okay. That is explicit consent. So if you want to process your employees' medical data, for example, you want to collect their medical information, you want to store their medical information, you should obtain explicit consent. In the workplace scenario, the question is not so much is this personal data or not, but it's more on have the employer obtain consent from the employee to process this data. Make sure your employment contract has a clause, or make sure there's an addendum on an annexure, which is the PDPA consent form or a PDPA notice, where you obtain explicit consent from your employee to process this data. Once you have that, you are basically safe. You can process the data of your employees, including sensitive personal data. So that is general principle. Second is the notice and choice principle, which is an employer shall prepare a privacy notice. It's a written notice informing a data subject that his data may be processed, why it is being processed, what is the purpose of processing the data, what kind of information that they need, who this data may be disclosed to, and you can access and you can change your data anytime you wish. There should be a PDPA notice. Coming back to an employment situation, make sure that you have a PDPA notice or PDPA consent form informing these employees that we will collect this data from you, we will process it, we will share it with who, how we will store it, and you got the right to amend it, you got the right to ask to delete it. It also includes if obligated data subject to supply the personal data, the consequences for the data subject if he fails to supply the personal data. So this is the notice principle. It is also part of the PDA that says that it should be in both the national and English language. This is something a lot of people forget. They just give the English language, they don't give the Bahasa Malaysia language. So preferably it is in both languages so that it can ensure that this employee fully understands and has been fully notified of how his personal data is to be used. This is the notice principle. Number 3 is disclosure principle. No personal data shall, without the consent of the data subject, be disclosed for any other purpose than the purpose for which the data was to be disclosed at the time of collection of the personal data, or a purpose directly related to the purpose above. Remember, just now the notice principle said that what this data is being collected for and what is it going to be used for. This principle says that it must only be used for that purpose and to any party other than a third party of the class of third parties as specified in paragraph 7.1e. Security principle, basically how you secure this data. A data controller and a data processor shall, when processing personal data, take practical steps to protect the personal data from any loss, misuse, modification, unauthorized or accidental access or disclosure, alteration or destruction by having regard to the nature of the personal data and the harm that it may result from the loss and misuse. For example, if there's a lot of data and it's very sensitive data, there's a high risk of being misused, then you must secure it differently from a less important data. So it must depend on nature and the harm that will result. You must give the adequate protection to a place or location where the personal data is stored, security measures incorporated into any equipment, the measures taken to ensure the reliability, integrity of the competence of personnel having access to the personal data, to the measure taken for ensuring the secure transfer of the personal data. If you are a data processor, you are a third party, you are a payroll software provider, you are a background check service provider, you are a data processor, you're not a data controller, you're a data processor. You also have similar responsibility to ensure that these data are secure, to ensure that there is no loss or misuse, modification, unauthorized or accidental disclosure of this data. Retention principle, meaning the personal data processed for any purpose shall not be kept longer than is necessary for the fulfillment of that purpose. It shall be a duty of a data controller to take all reasonable steps to ensure that all personal data is destroyed or permanently deleted if it is no longer required for the purpose. So data that is collected shouldn't be kept longer than is intended, that is necessary. When it's over, when it's no longer in use, you can delete them. There are some other laws which tell employers that you need to keep data for a certain period of time, but otherwise, if it's no longer needed, if it's no longer required by law that you keep it, then you should delete it. Data integrity principle, which is the data controller should make sure to take steps to ensure that the personal data collected is accurate, is complete, not misleading, is up to date for the purpose. And finally is the access principle, which a data subject shall be given access to his personal data by a data controller. Means the employees at any time can say, I want to see what is being collected. I want to see the information collected for me is accurate. If not, I want to change it. I have the right to change it. I correct it when it becomes inaccurate, incomplete, misleading, or not up to date. So there's a right to access. There's a duty to ensure that the data collected is accurate. There's a duty to ensure employees have the right to access their data. So these are the 7 principles. So as a data controller, as an employer, you deal with employees' data, you must always follow these 7 principles. So the law doesn't exactly tell you as employer, you must store it this place. You must keep it this place. You must update it every 3 months. Give form. You must let an employee check their data every 2 weeks. There's no specific thing that you need to do, but these are the principles that you must know and you must follow.